The first matter to come before the court this morning is State of Ohio ex rel. Mike DeWine versus Neil Wolfe et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for a rebuttal. You can see that we have a clock that everyone can see, so you know about the passage of time. Please don't use the names of any minors or victims of crime. I don't think we necessarily have that in this case, but this oral argument will be posted to the court's YouTube channel. So, yeah, we make that advisement on every case. We have read the briefs and we are ready to see when you are.
Thank you. Please, the court. My name is Dominic Vidantonio. I represent Neil Wolfe in this case, who was one of the two defendants in the trial court. As reflected in the brief, Your Honors, I argue this case in two different arguments. One is the classic abuse of discretion standard, which we claim applies here, and the other one is the constitutional argument, which we would like the court to consider and adopt. I'd like to start with the constitutional argument. The reason I think it applies in this case is, as I laid out in the brief, it's very difficult to say that you can distinguish what happened here with the classic compensatory punitive damages case, which is what BMW applies to. In this case, we have the state that was ultimately asking for restitution in excess of $100,000 for these various consumers. Zero was awarded. And then we have civil penalties, the word penalties even used, that were imposed where there was no restitution order. So our argument is to just get in the front door of that constitutional argument. You have that. You have compensatory and punitive. There's no real substantive difference between Gore analysis, and at least from that threshold standpoint. So then, you know, Gore looks at three what they call guideposts, and you know that's where we made the argument in the brief. And the guideposts, the Gore court said, probably the most important one is the reprehensibility factor. And they look at, you know, I mean, when you look at Gore, there was a 500-to-1 punitive versus compensatory. In this case, we're claiming it's even more because we have effective compensatory of zero, and we have $165,000 in punitive. And so the reprehensibility factor, when you look at the reprehensibility factor, the real inquiry is how reprehensible is conduct like failing to put a TIN on a contract. So you have a contract, the contract is executed. In a lot of these contracts, I mean there's 13 of them, right, that are really at issue. It boiled down to 4 at trial, and the civil penalties were administered in connection with 4 of them. But I think 3 of the 4 of those, the job was completed, the other job was completed by somebody else, but there's no damages, and if you have a contract with no TIN number, the question that's begged by Gore is, what's the reprehensibility of that supports the proposition that $15,000 is reasonable? We say that there's nothing, there's no reprehensibility. The same thing could be said with regard to the start-finish date. Okay, let's assume, and it's true, the cases that the court pointed to, the trial court, there wasn't a start-finish date. Okay, so how reprehensible is that in the sense that it should support a $15,000 civil penalty when there's no compensatory damages? So we think that if you apply that Gore analysis, and we think you should, because there's no logical reason not to, I mean, the same analysis applies. And that kind of dovetails into the abuse of discretion standard. Because the abuse of discretion standard looks at things like, you know, is it reasonable? Is it arbitrary? Is it unconscionable? And if you just look at the just look at the arbitrary factor. You have 11 different impositions of $15,000 for things like no TIN number, no start-finish date, failure to produce proof of insurance, taking in excess of a 10% down payment, and in a couple of cases not having a registration. So those are all different. So the fact that there's 15,000 attached to each one of those, an argument could be made it's arbitrary, because it just, on its face, it's arbitrary. I think you'd have trouble coming up with an argument contra to that. No, it's not arbitrary. Well, they're all different, and you tag it with the same stamp. You know, you just stamp 15,000 on it. And another problem with the case that, you know, we raise is that the statute, both of the statutes that are applicable here, there's two different Consumer Sales Practices Act at work, but they use identical language in the civil penalty stuff. It says, you know, the trial court may impose up to a $25,000 penalty. And so there's no guideposts, and that's kind of why I say that BMW is attractive, because it provides these guideposts. And if you accept the proposition that there is a constitutional issue here, that's step one. Gore says, yeah, there's a constitutional issue vis-a-vis compensatory and punitive. We're relating this statute to that. And first we're asking to realize or recognize or declare that that's the case. And then apply these guideposts to penalties that you're imposing with no restraint whatsoever. And we mentioned a number of times in our brief, and I think it is significant that...
Counsel?
Yes.
So you say with no restraint whatsoever, but didn't you just suggest or state that the penalty for each violation could have been $25,000 under the statute?
Yeah, so I guess that's a cap. There is a restraint. I guess what I meant is there are no guideposts. Like BMW imposes guideposts. Reprehensibility. You know, they say, what, a relation. They say, oh, they look at the disparity between harm suffered and penalty imposed. And so one of our arguments is, if you look at all four of these cases where this penalty was imposed, there's no evidence that there was harm suffered. And that's reflected by, in each case, and the magistrate goes through a fairly thorough analysis in the lower court that basically analyzes it and says, there was no damage. Either there was no evidence presented, or the evidence presented didn't establish damage. So you have that factor. And then you look at comparable cases. So those are the three guideposts that BMW sets up. And yeah, I agree there's a cap, but that's all there is. And the trial court certainly didn't say, you know, I'm imposing $15,000 because of this, that, or the other thing. And like I said, it just took 11 times 15, which seems to be face value, you know, just on its face it's arbitrary, because it's just all lumped into one category. So if there's, I mean, I think that obviously I'd like to incorporate the brief and everything in the brief, and I just think if you look at those two arguments, it's this imposition of this kind of penalty that could destroy a small business without any guidepost whatsoever under the facts of this case, with no damages, you know, restitution, no damages, is something that needs to be looked at and should be reversed. It should be at the very least reversed and remanded. I think it should be reversed and vacated, because there's no support whatsoever for it. Thank you.
Thank you. You will have 5 minutes.
Okay.
Good morning, may it please the court. My name is Rebecca Schlag, and I'm here on behalf of the state of Ohio ex-rel Attorney General Dave Yost, the appellee in this matter. About the only thing I heard that I agree with is that Mr. Antonio recited that this is an abuse of discretion review. This is not a de novo appeal. This case involved a lengthy trial before a magistrate whose decision was adopted by the trial court. any claim of trial court error must be based on the actions of the trial court, not on the magistrate's findings or proposed decision. So the question is, was there an abuse of discretion in the trial court adopting the magistrate's decision? I submit there was not. The magistrate's decision was rendered January 8th, 2021. Mr. Wolfe and Company have filed objections February 1st, 2021, and those objections were not supported by a transcript of the evidence or the affidavit as required by the Rules of Civil Procedure, specifically Civ Rule 53 D3 B3. In overruling Mr. Wolfe's and the company's objections, the trial court correctly asserted that because they failed to file a transcript or an affidavit in accordance with Civil Rule 53, the trial court could not disturb the magistrate's findings of fact. And on May 20th, 2021, the trial court adopted the magistrate's decision and toto, and specifically noted, number one, the failure to file the required transcript or affidavit, and number two, the court's own consideration and determination that there was no error of law or defect on the face of the magistrate's decision. On June 18th, 2021, Mr. Wolfe and Company appealed to this Court of Appeals. It's important to note that the two assignments of error now being argued to this court were never argued to the trial court. The objections Wolfe and Company filed simply argued the unsupported position that the civil penalties imposed appeared more punitive than remedial. On appeal, now we are hearing claims that this is unconstitutional, it's grossly excessive, it's unconscionable in light of the facts and circumstances. When you fail to raise an argument to the trial court, you forfeit the ability to argue same on appeal. For that reason alone, this court should affirm the trial court's decision. But let me briefly address the objections and the assignments of error to illustrate further why they're just plain wrong. Going back to the objections that the civil penalties appear to be more punitive than remedial, civil penalties are both punitive and remedial. They are not, however, the same as punitive damages or compensatory damages, as Wolfe argues. Civil penalties are statutorily created to remedy violations and to prevent future violations of consumer protection laws. Also, civil penalties are split between the Consumer Protection Enforcement Fund and the treasurer of the county in which the action is brought. Thus, the funds are used to support worthwhile remedial activities authorized by the legislature, as well as to subsidize the actual costs incurred by the governmental entities. Mr. Wolfe and the company keep arguing that the civil penalties are disproportionate because no consumer damages were awarded at the trial court level. But the Ohio Supreme Court in Celebrezzi v. Hughes held that civil penalties may be awarded in the absence of other damages. Under Revised Code 134507D and Revised Code 472207, the magistrate was authorized to impose up to $25,000 per violation. In this matter, the magistrate imposed far less. It's also important to note that Neil Wolfe and Neil Construction admit to the 11 violations of law that were found. They just don't want to pay $15,000 for each violation. So the objection that the penalties appear more punitive than remedial go nowhere, and I submit that it wouldn't have been successful even if Wolfe had provided a transcript to the lower court. By contrast, now the argument turns to, oh, it's grossly excessive and it's unconstitutional punishment, and both of these assignments of error fail. As to the first, it's not grossly excessive. The magistrate had the statutory authority to impose up to $25,000. She only imposed $15,000 for each violation. That can't be grossly excessive. Likewise, the civil penalties are not unconstitutional punishment. Mr. Wolfe and Neil Construction, they take pains to argue the applicability of the guideposts in BMW versus Gore. And that's not even apples to oranges, it's apples to sponge cake. This is not a damages case at all. Damages were never pled. The Attorney General does not need to prove damages in an individual case to recover civil penalties. It is true that consumer reimbursement may be sought as recovery, and it was sought but not awarded in the lower court. But proof of damages is not required to recover civil penalties. Again, they just don't want to pay what they've been ordered to pay. Moreover, the guideposts in BMW versus Gore would fail in this context because the guideposts are necessarily entwined with the facts of the matter, facts which were not submitted to the trial court by way of an affidavit or a transcript. And incredibly, Mr. Wolfe argues to this court, what's the reprehensibility of violating the law? What's the big deal in not including information which is required by the statute, or taking too large of a deposit, or starting work on a property without registering as a contractor? What's the big deal? Well, I submit violating the law is a big deal. And to understand the big deal, you need to understand the interplay between the CSPA, Consumer Sales Practices Act, and the Home Construction Services Sales Act, HCSSA. The CSPA has been in existence since 1972. It was created by the Ohio legislature to protect Ohio consumers from unfair and deceptive acts or practices. And it was enacted because at common law, consumers would have had to show proof of intent to deceive to recover. But under the CSPA, there's no requirement that knowledge or intent be shown. As the court in Thomas v. Sun Furniture Company held, to require proof of intent would effectively emasculate the CSPA and contradict its fundamental purpose. Under the CSPA, the AG can bring an action, or a consumer may bring their own action in which the consumer can then seek treble damages and attorney's fees. So for 40 years, the CSPA covered things including the construction of a single-family home. But in 2012, the HCSSA was enacted in Chapter 4722, and the CSPA was amended to reflect that transactions involving a home construction service contract are not consumer transactions under the CSPA. It was enacted as a means of limiting the economic damages a homeowner could seek concerning a residential project exceeding $25,000 in cost, so long as a supplier, such as Neil Wolfe or Neil Construction, complies with the mandatory requirements set forth in Chapter 4722, they may then avail themselves of its protections. So long as they comply with the mandatory requirements of 4722, they will be insulated from claims brought by consumers and no longer subject to treble damages as they would have been under the CSPA, and would only have to pay the homeowner's attorney's fees if the evidence shows he willfully violated the HCSSA. So contractors like Mr. Wolfe want home construction service contracts so they can limit their damages. And it's important to note both statutes reflect that the Attorney General can bring an action and can recover civil penalties of up to $25,000 for each violation. Well, you can't have it both ways. You can't limit your exposure for HCSSA contracts if you fail to comply with the mandatory requirements. So not giving the consumers copies of your insurance policy as required by statute, not including anticipated start and completion dates as required by statute, not including your taxpayer ID as required by statute, taking too large of a deposit, more than 10% of the contract price, required by, or prohibited by statute, those are big deals and those are violations of the law. And as to the, what's so reprehensible about not registering as a contractor before doing work on a consumer property, well, that's an incredibly big deal. And at the trial of this matter, 9 building officials from various Northeast Ohio communities testified that the reason for requiring contractors to register and to obtain permits before they do work on consumer property is for the health, safety, and general welfare of the residents. The act of registering triggers the officials to know that work is going to be done on the property. It triggers the need for inspections by the health district, by the building departments, to make sure that the structure is sound and isn't going to fall down, to make sure that the electrical work is up to code and isn't going to catch fire. It is a big deal for contractors to register as required by law. You can't just say, oops, I made a mistake, but what's the big deal? Turning to Mr. Wolfe's second assignment of error, that the penalties were unreasonable and arbitrary and unconscionable in relation to specific facts, again, that assignment of error simply fails. He's arguing that the civil penalties need to be tied to and related to the consumer's damages and harm, and they do not. Plus, Wolfe failed to file the transcript of facts and evidence anyway, that even if he had, the civil penalties imposed need only relate to the violations of law found by the trier of fact. And there were 11 violations found. 8 HCSSA violations and 3 CSPA violations. Without stiff civil penalties, suppliers have little to no incentive to ever comply with the CSPA and the HCSSA. They have no real reason to change their problematic business practices, leaving current and future Ohio consumers vulnerable to ongoing consumer violations. The possibility of the imposition of civil penalties provides the incentive for contractors to comply with Ohio's consumer protection laws. Actions have consequences. Neil Wolfe and Neil Construction broke the law 11 times. To claim it's just a technical violation or it's not reprehensible is untenable. They broke the law. The trier of fact in the trial court was in the best position to determine the amount of civil penalties. She heard the testimony of over a dozen unhappy consumers. She heard Mr. Wolfe's own testimony. She referenced Mr. Wolfe's tenor of wrongdoing in her decision and found 11 violations of law had occurred and that $15,000 per violation was merited. She was well within her statutory discretion to impose that amount, and the trial court correctly accepted the magistrate's findings of fact, since Wolfe did not provide a transcript or an affidavit with his objections. The trial court also conducted their own independent consideration and review and correctly determined that there was no error of law or defect on the face of the magistrate's decision. This court must properly affirm the lower court's decision. Moreover, contrary to Mr. Wolfe's assertion that $15,000 per violation was too high, I would submit that perhaps it wasn't a high enough deterrent, because Mr. Wolfe, within single-digit days of getting the magistrate's decision in January and the trial court's decision in May, was out securing more new problematic contracts.
Objection to off the record.
Your Honors, these suppliers do not listen to the law. They didn't listen to the court, but maybe, just maybe, they'll listen when money talks. Thank you.
Your Honors, we totally disagree with the proposition that the 32-page decision, written opinion of the magistrate that was adopted by the court is somehow not relevant. It's in the record. It describes the testimony. There's a lot of analysis in there. One thing that we're trying to point out is that one of the things it doesn't do is offer a rationale. And I think that is relevant to our argument. There's no rationale in those 32 pages for the imposition of 11 times $15,000 for 11 different categories of conduct. That's one of the things we're pointing out. And certainly the adoption of that by the trial court, of that magistrate's decision, doesn't offer a rationale. So that's one thing we're pointing out, and that's the reason why we're offering BMW, because it does have those guideposts, as they call it, and it gives courts an opportunity to offer some rationale. And we did object. No, we didn't purchase a $9,000 transcript to object, but we supplied it to this court. So the transcript is in evidence, and I submit that you can raise constitutional arguments at any time, and you can challenge the abuse of discretion of a trial court in making such awards. But of course the law speaks on that, so there's plenty of precedent on that, and that is going to go where it goes. But as far as the suggestion that somehow we're cavalier about this, like, oh, you're breaking the law, that's not the point. The point is truly reprehensibility. When you read Gore, I mean, it clearly explains why that's the case, and everybody, I think, can understand why that should be the case. When you're talking about something that's punitive, reprehensibility is front and center. Why are we punishing someone? For what? Well, because their conduct was reprehensible. Okay, how reprehensible?
Counsel, are the requirements under the two statutes at issue mandatory?
No. Well, requirements, I'm sorry, requirements for what?
Requirements for the contractor.
Well, it says that if you don't do certain things, then it's a CSPA violation. So it's not like, that's the only way I can answer that. So, it specifically says, if you take more than a 10% down payment, then it's a violation of Consumer Sales Practices Act. Yes, and then, yeah, so.
Thank you.
It's not, yes, that's the way it's stated. But I still think the analysis, an appropriate analysis, has to be done as far as the amount of what can only be described as penalties or punitive money judgments against somebody versus something that's compensatory. In this case, there's no question. They could say that, it's restitution versus compensatory, but it's the same thing. They're asking for money because consumers have been harmed, and as the 32-page magistrate's decision points out, it does get into that in some detail, that consumer so-and-so presented evidence of blah, 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 and we find no damages. Or it says something like, consumer so-and-so did not produce any evidence, so we do not order any damages or restitution, where clearly, if you read the entire transcript in context, the state was asking for, quote, in excess of $100,000, in excess of $100,000. Well, that didn't fly, so it's hard, you're hard-pressed, anybody's hard-pressed to logically say that that request for restitution is not the same thing as a request for compensatory damages. I don't think that flies, but that's an issue. And I think if you get there, then I think Gore makes sense to put some guideposts on what's clearly punitive as compared to whether there's any compensatory damages here, so.
So you have about 30 seconds.
Yeah, okay. Well, I'll rest with that and with the brief, and thank you for your time. Thank you.
Okay, thank you. I didn't mean to cut you short,
No, that's okay.
Counsel. I just wanted to let you know before you continue. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website.